A preliminary hearing in the courts of Arizona and in the federal courts and in most jurisdictions across the country, preliminary hearing is what we call a probable cause hearing. In other words, it's a probable cause hearing. It's an abbreviated hearing. It's almost like a mini trial where the prosecutor presents evidence to the court to prove to the court that they have probable cause to proceed on the charges. Again, this is different from the trial itself. At a preliminary hearing, the prosecutor is not under the burden of proving all of the elements of the crime beyond a reasonable doubt, as they will be in the trial. But again, this is just a probable cause hearing to determine if this prosecutor, the state or the United States attorney, whoever it is, has enough evidence to proceed on the charges that have been filed against you. At a preliminary hearing, there are witnesses that are called. The defense attorney gets to cross-examine the witnesses, and then at that time, this is not in front of a jury, it's in front of a judge. The judge will make a determination or a finding that there is probable cause to believe that a crime was committed and that the person that's being charged with the crime, the defendant, was likely the one that committed the crime, and that the prosecutor can go forward with the trial to prove his case. Or the judge will find out or hold a finding that there is not enough evidence to prove that a crime was committed and this particular defendant was the one that committed it. And so probable cause hearing is this a mini trial. It's a very abbreviated thing. Here in Maricopa County particularly, we don't see a whole lot of preliminary hearings because here in Arizona, they prefer to go to the grand jury, which is a whole nother conversation. But there are some instances, a lot of drug cases will get preliminary hearings. And so it's something that you should be prepared for. You need to talk with your lawyer about way in advance, because if you can get a favorable probable cause finding, in other words, the judge saying they don't have enough evidence, then that case gets chucked out early on and you don't have to endure the rigors of going through a complete criminal trial. So you want to talk to your lawyer, or get a good lawyer if you have a preliminary hearing scheduled, so that they can prepare for that, because that is an opportunity to get rid of the charges. So call our office, call a competent lawyer. We'll be more than willing to talk to you about this preliminary hearing that you have set.